Ms. Mascott, we heard several times from Judge Jackson that her judicial philosophy is in her 500 cases or whatever number that we have from her district court work. And then, so that was her answer to the questions about what's your judicial philosophy. How important is a justice's judicial philosophy in determining how they will rule on the bench?
Sure, Senator. Well, I think as these hearings and numerous Supreme Court nomination proceedings previously have indicated, is judicial philosophy is obviously paramount because, in contrast to the political branches, this body and the presidency, judges have a limited role to decide cases and controversies. And as Mr. Henderson is saying, Congress has a large role in establishing what the role and the jurisdiction of courts are going to be and the procedures they're going to put into place. And so, a judge's approach and philosophy in interpreting both the Constitution and statutory text is critical. And in the past, I think nominees that have gone on to serve on the Supreme Court and be committed and consistent and exclusive in their adoption of originalism and textualism have clearly discussed those methodologies, those philosophies, expressed commitment to them before this body, and articulated their grounding in the Constitution.
I'm going to ask Ms. Serrano. You're a former assistant U.S. attorney. You're familiar with these crimes where children are victims. Could you describe the sentencing enhancement around child pornography cases for use of computer, the number of images, pre-pubescent victims, but not so much on the mechanics of it, but explain why we have these enhancements?
It's my understanding that the enhancements were created to recognize the aggravation that the use of a computer or somebody with more images versus less images, or someone with images of very, very young children, they would deserve a higher sentence than somebody who was not had those characteristics with their offense.
Could you explain why possession of child pornography is not a victimless crime?
Yes, sir. So as I said in my testimony, these pictures or videos are real children. They're somebody's kid. They have parents, they have grandparents, they may have siblings. These are real children. And every time somebody views it, downloads it, possesses it, transports it, re-victimizes them. Can you imagine your most embarrassing moments on the internet forever? And this is not just embarrassing. This is brutal, sometimes often very violent, horrible conduct that victims know that somebody is out there looking at it.
Mr. Marshall, based upon your experience, which communities would be hurt most by anti-police movement? And is there anything in Judge Jackson's record specifically that concern you about her jurisprudence?
Appreciate the question. As I raised in my opening statement, what gets lost when we describe the victims of crime is particularly where those victims are located. And those that advocate an anti-police and anti-incarceration statements are advocating directly against those that they claim to be able to speak for. When I hear that Justice Jackson would be a voice for the vulnerable, very rarely do I hear that being described to those victims of violent crime who truly are the innocent and most vulnerable of the system as a whole. My broader objection as it relates to what I've seen of the record is when there is a judicial opinion drafted by the nominee in which she cites the New York Times for a quote that our criminal justice system is unfair and unjust. To me, that raises very specific questions about whether the nominee fully embraces whether or not our system is broken or whether or not she believes that the system works. Because to the extent that there continues to be the mindset that our system is unjust, then not only does it undermine the rule of law, but the ability of law enforcement to do their job and the public's confidence in the system in which we all hold dear.
Mr. Russell, mindful of the fact that Judge Jackson told us more than once that critical race theory never entered into her opinions or maybe even a matter of discussion, if a judge or justice is making decisions based upon that theory and those principles, how might we see that reflected in their opinions?
Well, thank you for that question. I think that based on my expertise in religious liberty and constitutional law, I think you always have to start with the original meaning of the Constitution and understand that regardless of the changing of the culture and what the social structure might call for, the standard never changes. And that ensures that there's an anchor and there's constantly a foundation to go back to. And so if you look at the Constitution through the lens of CRT, then you're going to assume that it's inherently flawed and incorrect, and you're less likely to view it as being something or a source that you need to go back to or a source that should be relied upon, and certainly not in the original meaning, because the original meaning is going to be inherently discriminatory if you look at it through that lens. And so if you see it reflected in opinion, say in a religious liberty case, you might be inclined to say change that original meaning in order to reflect the current culture's new understanding of what religious liberty should mean.
Thank you, Mr. Chair.